Definitions. So, over here we are going to discuss all the definitions that are there for tort. So, according to Salmond, tort is a civil wrong for which the remedy is a common law action for unliquidated damages and which is not exclusively the breach of contract or breach of trust or other merely equitable obligation. Then Wilfried defines tort as tortious liability arises from the breach of a duty primarily fixed by law. This duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. Pollock's contribution to the definition is tort is an act or omission, not merely the breach of a duty arising out of a personal relations or undertaken by a contract which is related to harm suffered by a undeterminate person, giving rise to a civil remedy which is not an action of contract. Then Fraser defines tort as tort is an infringement of a right in rem of a private individual giving of compensation at the suit of the injured party. Peter Brick's contribution in defining tort is this. He said that the breach of a legal duty which affects the interest of an individual to a degree which the law regards as sufficient to allow that individual to complain on his or her own account rather than as a representative of society as a whole. Now, Burdick helps in defining the term as an act or omission which unlawfully violates a person's right created by law and for which the appropriate remedy is a common law action for damages by the injured person. Keaton and Keaton, in their book, define torts as tort law is a body of law concerned with granting or denying claims of individuals or impersonal legal entities against each other for the award of damages or other forms of legal reliefs. Now, American jurist Edward Coinca writes, tort is an elusive concept, has defied attempts to formulate a useful definition. The one common element is that someone has sustained a loss or harm as the result of some act or failure to act by another. So, tort is perhaps the least bastion of a common law. Tort law remains uncodified and in large part unaffected by the statute. Section 2M, Limitation Act of 1963 defines tort as tort means a civil wrong which is not exclusively a breach of contract or trust. Now, there are certain characteristics of tort. The first characteristic of tort is this, that a tort is a civil wrong. So, one must be aware that there are two types of wrong. One is a civil wrong and one is a criminal law wrong. So, tort comes under the purview of civil law and its wrong is known as civil wrong. The distinction becomes important because, unlike in criminal law, there is no punishment in civil laws, and matter is to be sued by a person himself and not sued by the state. Further, the compensation is granted in for of unliquidated damages, which is not in the case of criminal law. The next characteristic is this, that a tort is an infringement of a right in rem. So there are two types of right in rem and right in persona. While the right in rem is available against the whole world, whereas right in persona is available against any particular individual, such as when a person contracts with another person and one of the parties has breached that contract, then the person of whose contract has been breached can only sue the person who has breached the contract. This is known as right in persona, that is, one can sue to one whom he has contracted. On the other side, every person has the right to the enjoyment of his own property, and any person who has violated or infringed, he will be sued and liable to pay compensation in the form of unliquidated damages. This is known as right in rem, which is available against the whole world. This way, the tort law in right in rem is available against the whole world. There is no need for any pre existing relation. The only requirement is the existence of right, and the right has been breached by a person. So, right in rem is not specific to any particular individual, which is the beauty of law of torts, and one can sue a person who has breached a right with no relation at all. Now, the next characteristic is that tort deals with cases related to legal rights. It is fair enough that tort deals with an only violation which is in relation to breach of a legal right. Though a person may economic or social laws, but if it had not breached any legal person, won't have any recourse in court under the tort law. Covered under this characteristic, there are two famous cases elaborating this topic. The first of this is Gloucester Grammar School case. In this case, the defendant has opened a school in front of already established school, which resulted in a decrease in the revenue of already established school. But the already established school have no recourse under law of torts, though there has been economic loss to the established school, but there is no violation of any legal right, hence cannot be held liable under torts law. The following case is adequate representation of maxim damnum sin injuriae, where there is a damage to the party but no legal injury has been done, which means no violation of any legal right, hence damage or loss without any legal loss. Thus, the court will not be able to take any action against it. The next is the exact opposite of the following maxim in injuriae sine damno, where there is a legal injury to the party but no actual or physical harm to the party. This way, the party will have recourse to court and seek damages even when they haven't caused any damage. The most case of subject is Ashby versus White. In this case, a person was stopped from voting despite his name on the voters list and proof of identity, but the person whom he wants to win has won the election, hence no loss caused to him, but his legal right was violated. He was entitled to damages and compensation. So now the next is remedy in the form of compensation. So in torts law, the remedy is awarded in the form of damages or as unliquidated damages, which are calculated by the court on the basis of loss caused. The method is different from what is in the law of contracts, where damages are already mentioned in the contract or can be easily calculated according to the agreed terms, also from what it is in criminal law, where punishment is given in the form of imprisonment. These differences are owing to the nature of law and the objective that they fulfill in the society, such as criminal law wants to create deterrence in the society, so it recommends punishment so that it can be set as an example in the society and no one should think of doing it again. Similarly, in contracts law, the purpose is business fulfillment or shape a particular transaction, so they have damages in their requisite forms such as special performance or pre-calculated damages. So is the case in torts law. The case is to restore the parties in their original position. Owing to this reason, the remedy is given in the form of compensation so that the party can be restored to the original position. The next is rights are to be fixed by law. To claim a remedy for the violation of rights, the rights should be recognized by the government. These rights can't be self declared rights for his own purpose, nor these can be based on previous consent of the parties. The rights should be acceptable by the government, and these rights changes according to the needs of the society. The government should recognize there exists duty on the defendant which he has failed to do and caused breached, and that breach was proximate for the loss caused, otherwise the claim will fail to sustain. Now, the law of torts is totally based on precedents. So, though a precedent play an important role in the development in any law, but in the case law of torts is the only source of law. There is a statute or act that specifically deals with the law of torts. Through this characteristic, the judgments of common law become an important and only source that recognizes these rights as a subject of law. The last characteristic is this, that the tort law is uncodified. So, codified laws are laws which have written statutes and acts on that subject, and changes take place by the process of amendment in the parliament. It can be distinguished from uncodified laws which don't have any written statutes or acts and have to rely on precedents and case laws, and change can be possible without the intervention of the government. Thus, the law of torts is totally based on precedent and developed through different case laws. It can be healthily said that the law of tort law is uncodified, unlike criminal law and contract law, which are completely codified, and precedents don't play a major role that it plays in law of torts. Thank you so much.